this computer. Recording in progress. All right, ladies and gentlemen, how are we all doing today? Welcome to episode 2 of From the Bench. I'm your host, Aaron Cartwright.
And I am your co-host, Laurel Curtis.
And today we have joining us from the 378th District Court in Ellis County, Judge William Wallace. I should actually, the Honorable Judge William Wallace. Judge, I should rename you. Let me see here. Honorable. There we go. I like that one. Just so that everybody remembers that you're the judge in this room. But thank you very much for coming, Judge. How are you doing today?
I'm doing well. Thank you very much.
Awesome. Let's go through a quick introduction really quick, just so that everybody else knows who you are. And then we will move from there into the questions that we've got. All right, ladies and gentlemen, Judge Wallace currently serves as the 378th District Court Judge in Ellis County. He started out his adult life, as a U.S. Marine Corps reservist at the age of 17, where he was stationed at the Dallas Naval Air Station. He transferred to the Army National Guard, where he was a helicopter crew chief until he graduated from Officer Candidate School and served as a combat engineer in the reserves and on active duty. After law school at the Oklahoma College of Law, Judge Wallace worked as general counsel and first-party trial counsel for Lloyd's Insurance Company. Subsequently, Judge Wallace served as trial counsel at Nationwide Insurance's trial division. Judge, I'm getting all this off your website, actually. But his trial experience includes defending individuals and corporations in civil litigation, serving as plaintiff's counsel in product liability and negligence subrogation actions. Judge Wallace stepped away from the comfort of a successful career as a civil trial attorney to pursue a calling to return to public service as a special prosecutor assigned to the Tarrant County Criminal Court District Attorney's Office. Additionally, and this is where I met him, additionally, Judge Wallace has been serving since 2009 as an adjunct law professor at Texas A&M University School of Law and his predecessor, Texas Wesleyan University School of Law. Judge Wallace, I don't remember if you remember me specifically, but I was in your insurance class all those many years ago. I made an A in that one, by the way.
I do indeed. How are you doing, man?
But awesome. All right. We've gone a little bit through your background. So just a couple of introductory questions. What inspired you to become a judge?
Well, let's start that off with, I didn't go to law school until I was 35 years old. So I didn't become a lawyer until I was 39. I finished law school like 2 days before my 39th birthday. And if you had asked me then, or in the 10 years following that, if I ever thought I'd be a judge, I would have told you, no, that ship has sailed. That is for young, bright guys like yourself who are focused at a younger age on the law. And I was not. I had, first career in the military and then in insurance. And then it was the insurance that got me interested in going to law school, because so much of insurance has to do with lawyers. And lawyers seem to be in every little aspect of our lives. And I just thought the lawyers I was working with seemed to make more money, have more fun, and have a much more fulfilling life. I wanted to see what that was like. So I went and did it. And I went to law school with the express purpose of never going backwards into the insurance industry, never going back to something I'd left behind, just moving forwards. And I wanted to be a prosecutor. And when I came out of law school, the jobs that were available to me capitalized on my insurance experience. So I went back to that. And eventually something happened where prosecution and insurance crossed paths. And that was when I got to be a special prosecutor for 3 years. And in that role, for the first time, the opportunity came up to consider whether or not I'd like to pursue becoming a judge. And I had some good advice from friends that maybe this was a good idea. I'd run some other political campaigns. I'd run one for a judge, one for a district clerk, one for a constable. To me, it just looked like another political race, which, if you can stand that, would put you in a position where you could really help people and really make a difference. And so for the last three years and a month or so, I've been the judge on the 378th, and the threshold question at the time was, did I really think I could make a difference? And the answer to that question was yes. And once I'd answered the question, it was full steam ahead, go into campaign mode, figure out how to get elected. And it worked out better than I would have expected. I mean, it worked out well, and I expected it to turn out well, but it was even better than that. I enjoyed the experience, the people I met, my opponents, all of whom have been in my court for something since then. So we all get along well. And it's a neat county to be a judge in. If you're a judge in Harris or Dallas or Bexar County or Tarrant County, you're one of 40 or 50 or 60 or 70 judges. I'm one of 6. There you go. I'm not good at math. I'm one of 6, and we kind of lean on each other. If you got a question, you got a colleague, and that colleague is going to steer you in the right direction. So when Judge Grubbs announced his retirement, the question was posed, would you like to run for this bench? And the answer to that question was, I absolutely would. I think I can make a difference. So here I am, and it's been a really, really fulfilling 3 years. So
that's awesome. Do you find it more fulfilling to be on, because I know you dealt with some seriously fun insurance cases. Do you find it more fulfilling to be on the bench or in front of the bench? Sorry, I know that one wasn't part of my prepared questions, but
no,
it was just.
It's a mindset change. You spend the first 6 months as a judge trying not to object. It's not your place anymore. You anticipate objections, and so when they happen, you're like, oh, I'm starting to figure something out. Well, that's not true. All you're figuring out is the style of that lawyer and being a lawyer. What I had to figure out was, could I sit through a trial without saying very much other than sustained or overruled? Could I sit through a trial and take everything in and be impartial? Because you're going to get up on one side of the case, and Laurel's going to get up on the other, and you're going to give me diametrically opposed viewpoints of the same set of facts. And so I've got to be the guy who can take it all in without making up my mind early. If when Aaron sits down, I'm like, oh man, that guy's going to prison, or that, those people are losing that business, or that kid's going to live in the other house. I mean, I have deprived Laurel of having the opportunity to get up and go, my learned colleague Aaron has got it all wrong, and she has the right to do that. So,
and she does on a daily basis.
Does she really? Okay.
The difference is that I'm not a criminal attorney. It's the small things. It's the small things that really make life worthwhile for criminal attorneys. All right. How does your background play into your thought process while you're on the bench? Because I know that obviously, you were just discussing how, you were in front of, you were a practicing attorney at one point in time, and now you've had to switch your mindset. But do any of your experiences from when you were a practicing attorney kind of come into play where you are right now?
Well, I will tell you, yeah, absolutely. I had an experience, about 4 years before I became a judge, maybe 5 years. I was trying a case in Bexar County in San Antonio, and we had a very contentious set of hearings. We were still trying to get to the bottom of an issue. Ultimately, I had lost the issue. It was a contractual issue where the non-prevailing party pays the attorney's fees of the prevailing party, and I knew my client was going to pay those attorney's fees. But I had an obligation to cross-examine the opposing counsel on the reasonableness and necessity of those fees. And rather than get into the detail of it, let's just say it was contentious. But the night before we were to have that hearing, my father passed away. It was sudden. Guy was in great health. He walked 2 miles on the Katy Trail that morning, but he passed in his sleep and quietly, and moved on to his next his next reward in probably the nicest, most pleasant way anybody was ever hoped for. So, but it doesn't mean it wasn't a traumatic event. I sure wasn't going to be in court the next day. This was a realistic conflict, right? And so I went down to San Antonio 3 or 4 weeks later to have that hearing finally. And the opposing counsel made some kind of, well, remark that didn't sit well with the judge, about, kind of my dog ate the homework kind of thing. And the judge read the obituary, looked at opposing counsel and said, you owe this man an apology. And he refused to do a thing. He sat there stone-faced until she got up from her counsel table, walked over to mine, extended a hand and said, I am sorry. I am sorry. And I shook her hand and said, bygones be bygones. Well, I never saw, his name was Judge Mary. I'll call him out, M-E-R-Y, great man. And I didn't see him again until I bumped into him at my first judicial conference 5 years later. He's sitting across the table from me at some luncheon. And I looked up at him and I said, you made an impression on me and I'm sure you don't know who I am. And he said, I sure do, Judge Wallace. And he remembered my name. And I said, I want to be that guy. I want to be the judge that is compassionate. And I handle about 90% of what I handle, 95% of what I handle is the family court docket. It's divorces, child support, child custody issues. They're emotionally charged. And I promise you that Judge Mary is in my head every day because I try to be that compassionate judge. So having been able to practice in front of a guy at a time when I needed to hear a judge say something that was positive, that was good, that was, could move the case forward without beating up on anybody, that guy sure showed me how to do it. And so I think the world of him, and he's a great example of how to be that kind of judge. So yeah, that one experience sticks out more than anything else in my mind. There, every case is different. You might say the issues are the same, but the facts are not, so I try to sit there with an open mind and listen to them all. So.
That makes perfect sense. And actually, that's a great segue. And kind of the next question is, what do you think are the hallmarks of a good judge? It sounds like, compassion and the ability to move a case forward without beating up on anybody too much are some of the hallmarks you think of as a great judge, but feel free to expand.
People have often said, made comments in passing, don't judge me, and my response has always been, I judge cases, not people. And that's true. You present cases. You don't present a defendant. You present a witness maybe, but you're not out there peddling reputation. This is a great guy. This is a bad guy. You're not out there to do that. You're out there to say, my facts are important. The law supports my position. I need to prevail for X, Y, or Z reason. So, when I hear people put on their case, the most important thing I can do is be as neutral as humanly possible until the moment I have to make up my mind. And I even if something is a difficult, emotionally charged case where you would think, oh, that's a slam dunk. It's my job to betray that and to give each side the opportunity to put on their case and never fall victim to the quick decision. So that, it's a challenge. There are days when, it's 7 o'clock at night, we've been going all day and you just want to giggle. You just want to laugh, something's going on and you got to keep a straight face. I've laughed once in my courtroom and it was something one of the attorneys said. It didn't affect anybody. It didn't call anyone out. It didn't victimize anyone. It was just, hey, that's more than 3 questions. It sounds like a silly thing, but at that hour of the day, it made me chuckle. And I looked up, and half of the courtroom was chuckling, and the other half was looking at me like, how could you, And I thought, okay, that's it. I can never laugh again in court, So to be a neutral is the biggest challenge. I think the other part is to not allow the system to be used in a manner in which it's not intended to be. probably the greatest example we have is people will come in and they'll have received service of process. Maybe it's a temporary restraining order or something. It has an effect on whether or not they can even see their kid. So they'll ask for some special dispensation from the court. I need a continuance. I've got to go get an attorney. To work with them as much as you can to give them the latitude to do that is important, but none of it can give up the protections you've afforded in a restraining order. So you have to kind of, you can't allow early decisions, protective decisions, things like a temporary restraining order to shadow the rest of the case, right? There might be other issues in other courts that are going to be sorted by the time we get to a final trial. And when I have those answers, it'll help me, it'll inform my result, you know? Does that make sense?
It does. It does. And we might get into TROs a bit later. But Laurel, you want to do motions practice?
You're fine. Yeah.
I always like to do motions practice, but I don't know if the judge likes to do motions practice. So I guess my question would be, how much time do you get to allocate to read motions or to review motions throughout your day, or when do you squeeze that in?
I'll be honest, we have a very, very busy docket. I could show you, give you an example. I'll hold this thing up. If you see all that little writing in there, every single one of those lines is a new case that'll come in front of me. So during the course of next week, we'll have, well, on Monday alone, we'll have 17 cases we'll hear. On Tuesday, I will have heard 3. On Wednesday, I'll have heard about 10 or 11. So depending upon what it is, I've got to read it, digest it, and all of it before we get into court. And I do that generally after hours. I come in on a Sunday evening. If I've got big hearings I'm going to hear, I'll read through the motions, set the files aside. We'll be ready to go the next day. A lot of stuff is stuff that you won't, it's a temporary order or something. It's something for which there's very little evidence offered in a motion. You just know, hey, they're going to come in and they want orders issued on 5 topics, but tomorrow they're going to tell me why. So I know what those are, and I kind of bunch these things together, so I know what I'm looking at. One day is temporary orders day. One day is maybe enforcements, you know, and enforcements are quasi-criminal. You know, if they can't afford an attorney, we'll appoint one for them. You know, that sort of thing. So interesting. Yeah.
That it is. So in that vein, having to digest so much so fast, how do you balance out what's presented in the motion with oral arguments and then what's presented in your hearing?
Well, it's funny. I was in front of a judge once, and we had been allocated, I think, 30 minutes aside to present some information, an argument on summary judgments. Something came up. We each got 5 minutes. That was it. And so I rolled back home, 5-hour drive, immediately drafted my motion for rehearing because I wanted to be heard on my oral arguments. And when I went back down, he granted the rehearing. I get back down there. I'm halfway through my oral arguments, and the judge says, "Mr. Wallace, do you have anything new for us?" I said, well, not exactly. I just want to make my oral arguments. And he said, "I've read your motion. If you don't have anything new to present today, then I think we're done." I thought, oh my, I've just wasted a 10-hour round trip to accomplish nothing. So, so long as it's an issue I need to read, you know, where they present their law and facts in the motion, I'll read and prepare. Not a problem. I don't think that that everything is presented in that format. Some stuff is just immediate relief, and you've got to get in there and hear it. So, but anyway, I'm not sure if I answered your question entirely.
No, it was just kind of how you balance them. Like, do you prefer to read or do you prefer to just hear it?
Well, we're coming out of COVID, so there was so much that was submitted and heard by submission that I'm thrilled to have people back in the courtroom pointing fingers at each other and making arguments. That's the essence of what we do. All of us want to go into a courtroom and be a showman for at least 5 minutes, at some point. And maybe, Laurel, that is or isn't what you want to focus on, but at some point you'll have that moment in court, and you'll know that, wow, this was cool. I was prepared. I was meant for this. But I would, I absolutely don't mind preparing by reading, but in balance, I don't know what the lawyer thinks is important until they come in and make their oral arguments. When they will come in and highlight it, I might find out that they listed 6 points of law and they argued 1. That's what they want me to know. That's the thing that they think their whole case hangs on. So, and I've had different motions, we need more time because we've got all these witnesses we have to put on, and they'll come back in and put on 1 more witness. So I'll shake my head and I'll go, they just wanted more time for that 1 witness. That's what they want. So I can, you learn things,
And speaking of like presentation of emotion, when you get into a hearing, do you prefer to have a couple of minutes of technical aspects? Do you want some background on the case itself? Like, do you need a preface before you hear a specific motion?
Well, the first thing I'll ask when we go into court is, are there any pre-trial matters before we go on the record? And there might be. They might say, this is a necessary party that's not present, or we're about to argue a motion on which I have not received discovery from the opposing side, and I have a motion to compel on file. I'd like this motion put off until that's heard, and they're forced to give me the discovery I've requested. So you get the pre-trial stuff out of the way. Then when we move into the actual motion on the record, I'll ask either side, do you want to present? You want to make some sort of an opening argument? Yeah, sure we do, Judge, or no, we don't. I'll waive that and go right into my first witness. So even on a motion in my court, there are witnesses called. So I'll hear what they've got to say, and that'll fold right into it. So it's the order for me is simply pretrial, opening, witness, and then everything takes the basic trial format of the movement, then the respondent, then any kind of counter or any further argument from the movement, and then we move into the closing. So it's to deprive anybody of that process doesn't sit well with me,
So kind of a follow-up to that question, though. There are some judges that, all of y'all's dockets are extremely busy, but you're a year and a half down the line, the case is still in front of you. Whenever you're coming up for a hearing on something, is it that little bit of, Your Honor, just a reminder, this case is about XYZ, that you would like to have before, or do you just want to, have the parties skip straight into the technical aspects? Your Honor, we're here for A, B, and C.
No, I think depending upon the case, and the attorneys know better than I, there's a greater context. And when they want to say, hey, listen, if I can give you a quick primer on this, let me give you a quick, reminder of where we sit and how we got here, a little procedural history maybe, or something along those lines. I always appreciate that. It is not always necessary, but it is sometimes vital. I had a hearing earlier today on some temporary orders that had to do with going back to school for some kids. It was instructive to have the recap of where we were this time last year, because the case is still open, still pending, and not resolved. So it's a perennial topic. We're going to come back a year from now, and the issue will still be there. Either they'll solve it on their own, or they'll come back to the court for some guidance. So
that makes good sense. Actually, that brings a lot, and I hope that the people who are watching this and will be watching this whenever they're trying to do their due diligence on yourself, kind of listen to that advice. Should make for a much more streamlined process. That actually brings us to our section on hearings. Some question with regards to hearings. Do you prefer electronic or physical exhibits?
Well, let me preface that by saying I have a brand new courtroom. Okay, so I've got all the high-tech gadgets that we can come up with in humble Ellis County, and we're not flashy down here. We didn't ask for a super courtroom. like you might find at some of the big courthouses where they can take a big case upstairs to the super courtroom. But we designed our courtroom around the subject matter we handle. I have 3 trial tables and not 2. We don't use drop-down screens anymore. We've got large flat screens on the wall, and every trial table has got a way to hook a laptop up with an HDMI plug. And I have a menu at the front where once they've made their predicate and they want to present their evidence, they can certainly put it up there on the screen. I love to see the evidence provided in electronic format. You still have to present it in a format that the court reporter can preserve. So maybe you've got 30 exhibits and all 30 of them are on a thumb drive. When you're done presenting them, that thumb drive's got to go to the court reporter because we've got to keep the record, right? But it is there is no prejudice. I mean, there's no discount. There's no failure in a case that is presented with sheets of paper, or photographs. But we have the tools, and for those that want to learn how to use the tools, it can make them very effective in presenting the case. Probably the things that are more effective now are things like video and audio testament or exhibits. Now they're up and in your face. They're huge, so it's easier to follow. And the complication is we use WebEx. Some courtrooms use Zoom, but it's the same concept, right? Hey, I want to share my screen. Well, once you share your screen, I've lost my witnesses. I don't know where they are. They're hiding behind some piece of paper that's up on the screen, right? So that can complicate things when it comes to keeping a record. A court reporter is a lip reader as much as a listener. So once they stop seeing, Aaron or Laurel's lips move, then you've just made the record maybe a little more difficult to keep. So
that definitely gives us some insight there. You spoke earlier about giving parties, equal time or not equal time, but not depriving anybody of the chance to tell their side or their story or whatnot. What is your "I've heard enough" signal, though?
Oh, I don't know that I have a signal like that. Probably the best signal I have is a chess clock, so I will tell people at the beginning of a hearing how much time each side has. And when you say pass, that's the timer. That's my reminder. And I've got little cards, and I'll put them up for people. You have 5 minutes left. You got 10 minutes left. You got 2 minutes left. Whatever they are. But there is not a hey, that I've heard enough. Go away. I don't do that. So
sure
I
it's
think
not
that maybe.
I was going to say, are you sure it's not a counselor? Do you have anything new to present?
Yeah. And well, that sure worked for me. But I think once they have each gotten to the point where I feel like they've presented everything they have, if I know they've got a half a dozen more witnesses waiting in the hallway, I might ask them, is there anything more you feel you need to present? You're running out of time. Because I try to help them budget their time. It's important for me to help them help them budget what little time they have. We're all overbooked time wise. I mean, we could have hearings in this court every morning from 8 until 10 p.m. at night. But lawyers are verbose, so you have to give them an opportunity to economize in their own setting, So
I mean, in some sense, we are paid by the word, still even. All right. What makes for a good hearing presentation in your eyes?
There are a couple of key things. One is, and I have to remind witnesses of this, but sometimes lawyers, it helps to remind them too. But evidence comes in through an examination of questions. The witness answers. Another question, the witness answers. What I remind the witness is it's not a conversation, so don't get involved in any kind of a banter. And it's not an argument. It's simply questions and answers. Only one person will be asking questions. The witness will be providing answers. It's that simple. And to the extent that an attorney can remind themselves not to cut the witness off. And I have to remind witnesses all the time, let the attorney finish the question and then give me your answer. Those are just sort of basic ground rules. And some attorneys are very, very good at keeping that flow going unobstructed. They present a great case. They don't talk too fast. They don't drag it out, you know. But witnesses, it may be the only time they've ever been on the stand in their life. So you got to kind of give them a little bit of credit to figure it out, and then a little bit of a nudge or an adjustment if you need to get them to kind of fall in line with the format. Because two things happen: is one, the case can get muddled, and two, the record can get muddled, and you don't want that. So
makes sense. How do you feel about charts and graphs?
Oh, well, visitors. Okay, charts, graphs, aids to the court, essentially. It depends on if you're presenting as an aid to the court, if you're presenting as evidence. If it's evidence, you've got every right to bring it in. If it's an aid to the court and it's a summary of some prior testimony, or some sort of a way to get your head around something that was a complicated concept when it came out of this expert's mouth, because, you know, experts, you know, they talk in jargon, they're paid to talk in jargon. But when you put it in black and white, you know, with you know, an x-axis and a y-axis, and this is the total amount consumed by the, you know, the fraud upon the estate or whatever might be presented, they're always helpful, always helpful. So, but I used to put on forensic financial accountants when I was a prosecutor. So to me, that stuff makes perfect sense. So.
All right. I'd like to ask you some trial-based questions. You're up for that. Let's go back to law school for a second. How do you define hearsay?
Oh, that's probably the most complicated, most unspecified answer out there. But generally speaking, we're just talking about, you know, an unsworn declaration that is made outside of the courtroom. So a declarant, the whole idea of hearsay is to add some indicia of reliability and truthfulness to some statement that may have been made elsewhere, right? And so we have all sorts of exceptions to it, right? I might be asking you what time you got home with the children, and I won't actually be asking you, I'll be asking somebody who you told that to, okay? Outside of a court hearing, you know? I'm not doing, I can't bring that in to show the truth of the matter asserted. I might be bringing that in just to show that you had custody of the children on that day, an ancillary fact, right? And so being able to distinguish between the ancillary fact and the truth of the matter asserted, that's a huge thing. And it's a tough concept. Hearsay is the toughest rule because it's so amorphous. But literally, you know, unsworn statements, written or oral, made outside of the presence of the courtroom are that's the basic definition of hearsay. And then when you keep in mind that the reason we have these rules is so that we don't have a lot of, you know, he said, she said coming in that's totally unreliable. When you look at the exceptions are the areas where we've codified a belief that there is some indicia of truthfulness. What do you have when somebody says something and you don't get to confront them about it? You've really got a Crawford problem. You have a confrontation issue, right? And so, well, if they said that, I should be able to ask them about it. Well, yeah, maybe you should. But what if that was said in response to an email that you sent? So you got sort of the reply letter doctrine going on, right? I mean, I love all this stuff. This is just the funnest part of it. You know, I'm not some, you know, goofball nerd flipping through the evidence code. Now I might be flipping through the family code the whole time, but the evidence is, and this is, I guess this is the kind of nerd I am. I have two sets of CDs in my truck at all times. One is maybe a book on tape because I don't want to fall asleep when I'm taking a long drive. The other one is my Sum and Substance CDs from the bar prep. in 2005. So why do I care? It's interesting. That's it. It's just interesting. So I mean, literally, you can stop me. It's not in my truck. It's in a Miata right now. But I'm still actively. And when I finish, I just pop the first one back in and go back through it again. So anyway.
That is remarkable. That is absolutely remarkable, and that is some dedication too.
Well, it may make me remarkably boring, but it is when you're sitting there having coffee shop conversation, and they can say, well, you know, how is it that you can bring in some sort of evidence of, you know, prior character behavior to show conformity with that behavior when it's prohibited? Well, the mnemonic is Miami cops. It shows motive and, you know, intent. And, you know, you start going back through that mnemonic and people are like, you remember that from law school? No, I don't. I remember it from last week. I'm cheating. I listened to it in my Miata last week. So anyway,
That's phenomenal.
common schemer.
God.
And I mean, it's all there, right? You know. So anyway.
That being said, and knowing that you know go back through those things on a regular basis, in a bench trial, what is more important, procedure or the practical impact on the parties?
Well, let me kind of structure that. There is a practical impact on the party, but there are some procedures that just don't matter anymore when you're doing a bench trial. The motion in limine doesn't matter. I'm the trier of fact. So if you need me to rule in the motion in limine about something you don't want me to see when it comes back to trial, I've already seen it. So it's some things don't really apply. I do believe that, you know, you've got to follow the rules of civil procedure. You've got to follow the rules of evidence. You've got to let the bench trial unfold as fairly and evenly as you can. Now, where's the challenge? The challenge is in family court, in bench trials, you have a higher percentage of pro se litigants than maybe any other area other than maybe traffic ticket court, okay? Until you get, I mean, we're a district court, we're a felony level court, and we've got big issues going on that involve money and children and lives together. And when you have somebody in there who wants to argue that vehemently themselves because they believe in themselves and their case, but they don't know one thing about civil procedure, evidence, or that whole process, then it's a disability for them. So where do we accommodate more the impact on people rather than the letter of the procedure? Probably in pro se cases to the bench. But I will tell you this, the bar rises to that level. They're careful because you go into court, Laurel, and you've got a pro se litigant on the other side, and you've got some gigantic issue that matters to your client. You could turn around to your client, wink, and say, watch this, and wipe the floor with that person because they don't know what you know, right? They don't know how to go about it and to do it. But on the other hand, if you treat them professionally and you allow them to make a couple of mistakes, probably the best example is there are times when, you know what a predicate manual is, right? You know what the predicates are to bring in an exhibit. Pro se litigants, they've never seen one. When you say the word predicate, they think you're talking about high school English. They don't know what you mean. So oftentimes members of the bar, officers of the court on the other side of the case will let something in that they know if they objected to would be out. But they do that because they're not trying to win on procedure. They really want to win on the merits. They really want the case heard, win on the merits. It's far less likely to come back again if they win on the merits. So it's not so much me. It really is the bar accommodating the process. I'm not saying those lawyers don't walk out in the hallway and go, man, I don't want to do that again. These pro se litigants, they're so hard to deal with. I get it, but it shows a lot of character and patience when they tolerate it well. So.
I've been on the other side of a pro se and a medium-sized case, and it was an experience.
Yeah.
Is a good way to put it. But
just because they don't have a lawyer doesn't mean they don't have a case. It just means they're going to have a harder time presenting it. I mean, it's guaranteed they're going to have a harder time presenting it.
Absolutely. So that's a little, we got into bench trials a little. Let's talk about jury trials. What is your preference on instructing the jury and voir dire?
Okay, I'm going to have to do this based upon my experience as a lawyer, because it's been 3 years and I've got a family docket. And although we had a bunch of jury trials on the docket when COVID hit, not a one of them has gone to trial yet. So in 3 years, I haven't had a jury. So go back and ask your question again, and I'll try and give you an answer from my standpoint as a lawyer.
Let's ask it this way then.
Okay.
As far as voir dire is concerned, when you get the chance to do a jury trial again,
yep,
will you let the lawyers take the lead on voir dire, or do you think it's important for you to step in and ask certain things or give certain instructions?
There are a few instructions that the judge must give, but you have to let the lawyers run their voir dire. The lawyers know what is important to the lawyers. So I'll give you an example. In a criminal trial, if I'm prosecuting, I got to make sure everybody that hits that panel is certified to handle whatever level of punishment that case might be. Let's say it's a first-degree case. That means the punishment range is 5 years to 99 or life. Man, that's a big, big swath. And it might be a property crime. It might be a fraud. That was what I presented. I presented a lot of white-collar cases. So if somebody has stolen money, a potential juror might say, I could never send someone to prison for life for stealing money. I just could never do that. Well, unless they're willing to conceive a circumstance in which they might be able to give the full range of punishment, they're not qualified to be on that jury. So do I want the judge to qualify the jury as regards the penalty range, or do I want to do it as the prosecutor? I want to do it as the prosecutor. And so if I, as a judge, were to get in the way of that, I now set a standard that might not satisfy either the defense or the prosecution. So I got to let them, and I'm not saying they're going to make mistakes, but they know what they're trying to do, right? So if I had someone stand up, as I did once in Fort Worth, and say, I could never send someone to prison for stealing money, even if it was $1 million. Okay, well, what if it was your $1 million? Or what if it was, I think I said, what if it was your mother's $1 million? Still couldn't do it. What if it was your $1 million? Couldn't do it. Okay, let me rephrase it. What if it was every dime you'd ever saved for retirement, and now you never get to retire? You have to work until your last day on this earth. Oh, he'd go down for 99 plus 1. Okay, good. You can be on my jury. So all they have to do is conceive a circumstance in which they might award that punishment. It doesn't mean they will. They just have to say, I can now conceive of a circumstance in which I might. And I really think the lawyers know best how to get there. All lawyers were baby lawyers once, right? So maybe their voir dire was not as good in year 1 as it might be in year 20. But I watched people do stuff and I learn it, and it's fun to watch them do it. I watched an attorney out of South Lake one time just look around that jury pool and call people by their first names and ask them all sorts of questions. And when it was all over with, I looked at him like, how did you know all their names? He said, I didn't. He said, I looked at the list. I memorized about, 6 first names that were going to be on that list. I knew there were 3 or 4 of each. So it was very simple. I said, David, a hand went up. I'd look at the person and ask them the question. They thought I knew them. I thought that was interesting. It was just an exercise in him building rapport with the veneering panel. Yeah. But they thought the guy was brilliant. So note to self, okay, learn some names. There are some things you could do. So.
No, that just became the number one voir dire note on my list. Learn some names. Got it.
I feel
So
like we get
one
all
of,
the inside information through this series. It's great.
Well, I hope it's helpful, but I also hope that anybody watching this will also keep it in context. You know, it is. This isn't a game; it's a profession. And as much as we get a chuckle out of a good case every once in a while, the best goal they can have is just to get better at their trade and their art. You know, it really is a trade, and it really is an art. So.
well, and that's one of our goals with this series is what can we do to be better, to do better. I have one last question about juries. What makes for juror bias, or how would you detect juror bias?
I don't know that I, as a judge, can impute some framework of what appears to be bias on a juror. Jurors don't generally. I'm not one of those judges that solicits questions from a jury. I won't be that guy. So how do I? Bias is something that by the time you certified your panel and sworn them, you've covered that question. You know, so once they're in the box, and you believe they can be fair and impartial. So if it's in the voir dire process, the way that you ferret it out, the way that you identify it, and the way I did as a lawyer is when somebody says or does something that you think, oh, I don't want that guy on my jury. Don't want him on my jury. I don't think he could be fair. Then because I'm going to strike him, right? There's two ways to strike, right? Preemptively or for cause. You only have a certain number of preemptive strikes, but there's an unlimited number of strikes for cause, right? Because you're asking the judge to say, this guy can't be impartial. So when they say something that just doesn't sit right and it seems impartial, my job is to try and rehabilitate him or her as best I possibly can. So you're telling, like I had a question one time that came up, who here has a moral objection just simply sitting in judgment of another human being? Yeah, that's fair. It's a fair question. Some people do, and they want out. I'm not going to do it. Okay, I look at the juror card. Colonel, I see you're a retired military officer. Did you ever sit on a courts-martial panel when you were in the military? Yes, I did. Okay, how many times? Oh, a half a dozen. Well, so you have been able in the past to sit in judgment of somebody. Why is this different? Well, I no longer have to. Well, in fact, you do. I mean, this is a civic duty, and you've been summoned here. I mean, that's the reason it's called a jury summons. You've been summoned here. We didn't hang a sign out front that said, hey, prospective jurors, come on in, free cup of coffee. It's a warm place to sit. We said, you must come. So here you are. So you've been summoned. So it is your duty, and you have an obligation to do this. Why do you now have a moral objection you did not have when you were in the military? Well, the prison population is growing. We're not rehabilitating enough people. I'm just not going to send people to jury, to prison. All right. Would it matter to you if in the punishment phase of this case that nobody was asking for anyone to go to prison? They were only asking for, no, it sure wouldn't. I just can't sit in judgment. I've now shown the judge that every permutation I can go to, every little path I can go down, this guy is going to refuse to be impartial. So I'm going to make a strike. I'm going to ask him for a strike for cause. And generally speaking, that sort of preface will get the person struck for cause. So what can I do best? Try and rehabilitate him, and that will cause their bias to surface to the top in random and sometimes kind of ugly ways. But the reality is, if they shouldn't be on my jury, I don't want them on my jury, right? And if the bias is there, I'm not. Bias is not a bad word. Bias is a disqualification. So in the world of the juror, bias just simply means you can't get your head around being impartial about a particular issue. That's all it is. So that's probably the best tip I have is try and really rehabilitate him as best you can, and it won't be an ask. It'll be a identification. Sir, we've obviously identified this person's not going to be able to sit impartially, so we'd like him to struck for cause. Versus asking, saying, "Hey, Judge, I really would like you to say this guy or this girl just can't be impartial." You know.
That makes a whole lot of sense, and that is going to be. I've got a couple of jury trials that if we can ever get the courts back in, or well, the courts are in session. The COVID and the whatnot is what's messing with those dates so far. Because now that everything's going again, it's trying to pack into one very tiny spot, and that's just not working out. But that I'm going to remember. All right, let's we've got a couple of sections left, and then we will let you go. So as we move on to the more general practice tips, what are some of your biggest pet peeves? Things that you're like, no, attorneys, practitioners, litigators, whoever's watching this, do not come to my courtroom and do this.
Let me start by saying every one of us makes mistakes as lawyers. And just because you get elected or appointed judge doesn't mean you're now fall free and you never made mistakes. So sometimes the things that are pet peeves are when I see people do stuff that I did myself and was embarrassed by, gosh, don't come in unprepared, you don't have to, by being prepared, you don't have to have a big red rope file with 60 exhibits in it. You have to be prepared to argue your case and make it impactful. Sometimes the most impactful argument is 3 exhibits and a really good oral argument and 1 great witness, So distilling something for the court versus drowning the court is always a good thing. I've seen people during the world of COVID, and you can email me your exhibits, so we'll print them out. We had to finally put a page limit on it because people don't come to court with 600 pages of exhibits. But if we're doing this via COVID, I'm just going to email 600 pages of exhibits to the court, and they'll print them out for me. No, we're not killing trees for a hobby around here. Figure out what you need, bring what you need, put on your case. You're going to do well if you give it a little bit of forethought. One of the things that people probably overlook the most is witness prep. You've got to have the witness know when they get on the stand to, answer only the question they're asked. Don't go off into some tangent. I was a witness in an employment case many years ago, and I was asked as part of my biography when I moved, did I have this job? My answer was no. I no longer had that job. I had this other job. Well, my lawyer picked me up, took me in the hallway, put her finger in my chest and said, don't be helpful. Every word that comes out of your mouth is evidence, and I got to deal with it. The answer was, did you still have this job? There were only 2 answers, yes or no, not this paragraph you threw in after that. And I was like, I get it. So there are times when you see, people that have not prepared their witness. The other thing, and the measure that remediates that immediately, is if a lawyer knows how to control their witness. If the witness wants to go down the world of telling their story on the stand, this is my moment to tell my story. They have a different impression of their time in court than we as lawyers do. I need them up there to say 4 things. That's evidence I need. They want to get up there and have their moment in court. They want this great, opportunity. So if they get up there and they get off script or they get off point, there are lawyers that'll say, okay, listen, I need you to look at me. I'm going to ask you a question. I only want you to answer the question I'm going to ask you, and they'll do that. That's more effective than objecting and saying objection non-responsive to the question that you asked the witness, right? It makes you look disorganized, so there are 2 ways to go about it. That's probably another pet peeve is consider carefully the objections you make in court. Not just because you can doesn't mean you should, right? So if it appears that your objections are simply to derail the examination of opposing counsel, throw them off their game. They're going to get their case out. It's going to happen. I'm going to listen to their case. So just relax. It's okay. Make the objections you feel really appropriate. Make the ones that have an important impact on the case. You know, they want to bring in a letter that they got from somebody saying what a great mom or dad they are, you know, and that's hearsay, and so you want to object to it. Maybe that's fine. But then the next thing they want to put on is a report card for the kid. Well, maybe that's probably also hearsay, but where's the harm in letting it in? Eventually, we're all going to find out that the kid's making F's or making A's, right? So, you know, you sort of make a value judgment as a lawyer where you're going to sort of draw the line in the sand. And there's some awfully good lawyers that will cut their opponent's case to the quick just by being that careful, courteous person who is saving their objections for when they really matter. You know what I mean? So.
I do love listening to the tactics of others without actually having to go against them first. What are some of your favorite things that you want to see more from lawyers? And at the same time, what do you, well, in the same vein, kind of what do you want more lawyers to do? I know that you talked a lot about preparation, you know, reserving your objections for kind of when they would really matter, and just being a little bit more generous towards your opposing counsel or the opposing party. But what are some of the favorite things that you see and some things that you wish more lawyers would do?
I will say that probably one of the most effective things lawyers can do when they come into my court is prepare before they get there, and then present a sheet that is their requested relief. I know what your motion says. Your motion says you want these 5 things. Your requested relief says what specifically you want. And it might also say in there, and in the alternative, this, because oftentimes, you know, I'm not going to have the opposing party taken out in the hallway and beaten or something. So if you're not going to have the opposing party taken in the hall and beaten, then we just like them walked out of the building. You know what I mean? Give yourself a little room to get relief that the court would probably sign on to, right? So.
Do you want that presented at the beginning? Oh, sorry, there was overlap. Do you want that requested relief presented at the beginning of arguments or at the end of arguments?
No, at the beginning. And here's and don't offer it as evidence. Give it to me as a worksheet. So I'm looking at your sheet of paper. It's sitting next to Laurel's sheet of paper. You're wanting not diametrically opposed things. I might find immediately that each of you are asking for the same 4 things, and then you have 3 things that you disagree about. All of a sudden, you've just now created a context for this hearing that makes sense to me. These are the 3 things we're fighting over. You know, Aaron wants his client to go home in his Ford F-250. Laurel wants her client to go home in her Mercedes-Benz. Aaron wants to have Laurel's client be the primary parent, and Aaron's client wants an extended standard possession order. I look at Laurel's request for relief. I want to be the primary parent, and I don't want him to have anything more than an extended standard possession schedule. All of a sudden, you guys disagreed on 4 things, and there really wasn't a disagreement to be had upon that. So it sort of leads into the next point, which is one of the best things you can do before you come to court is speak to opposing counsel in the hallway, right? Do we have anything we agree upon here? Yeah, not a thing. Your client's a horrible person. Sorry.
So believe it or not,
your client's a horrible person. Go ahead.
Believe it or not, but you are on episode 2, but you're the second judge to say that. I don't know if you watched the interview that we did with Judge Matthew Wright, but he said almost the same thing, that one of his issues was, guys, have y'all even talked to each other prior to showing up in this courtroom yet? Like, what's going on here? Why can't you agree on something? So I find that very interesting. I wonder if that's going to be a theme.
It might be, you know, but there is also something, and that's the beauty of coming out of the COVID. Hopefully, if our fingers crossed, everything moves smoothly, right? Is when you're back down at the courthouse, you've got the you've got the pressure cooker plugged back in, and every witness has more pressure on them to tell the truth on a witness stand with a judge sitting next to them and the court reporter sitting in front of them, and opposing counsel and their counsel sitting at tables out there, than they do when they're looking at a video screen. If I'm a lawyer and I'm going to go down to the courthouse on Monday morning and I've got 6 criminal cases and I've got 6 clients and I know I'm going to be dealing with a couple of different prosecutors, I now have the context to work out a half a dozen disagreements, perhaps. So hopefully they'll talk beforehand and work them out. There's a lot that can happen when you will do it in person, but you still got to do it. Just because you went to the courthouse doesn't mean you have to go into the courtroom and start throwing arms and making gestures and pointing at people and that man right there did this, that, or the other. Yeah. Save the jury argument for the jury. Exactly. Yeah. Exactly.
Very nice. All right. So just generally speaking, I know that there may be some things that we have not covered in this particular area, but what else do we, the lawyers and the individuals practicing in front of you, need to know before we practice in front of you, if there's something that I haven't asked about specifically already?
Yeah, let's talk about a couple of issues that come up all the time. I'm in a small county. There's 6 judges here. So the local attorneys, they're afraid of getting some, big Dallas lawyer who's going to come down here and try and run over. The Dallas lawyers, they're afraid of coming down here and getting hometown, right? The reality is you've got 6 judges in this town that always try to be fair. There is not a bias in favor of the local lawyer because they're the local lawyer. And there's not a bias in favor of the tall building lawyer because, I don't know, they bill $650 an hour, right? We don't care about those issues. I've been hometown by the best of them. I've been to a small courtroom, I had a lawyer tell me one time after he had won a motion, Doug, I'm so sorry you had to come down here and see that. I just wanted you to know you were fishing in a pond that I dug and stocked myself. And I thought, golly, that was just the folksiest, nicest way of saying get out of town. I'm gonna beat the pulp out of you when we come down to a jury trial. And I called my boss in the car and said, we're settling this sucker. I can't do this in this county. Nobody can unless you're local. Let's see. There is no shame in telling the court. It's the first I've been in court on this issue, Your Honor. So I beg a little leeway. Not a problem with that at all, right? Treating others in the courtroom with respect is a real plus. There are people who are always going to be pit bulls, and they're going to charge and strain at the chain every time they get a chance in the courtroom. But some of the most effective lawyers I've ever seen are the ones that are just gracious, courteous, and professional to the other side. It just works out that way. And generally, I think that that's easy to do when there is I think something happened to my camera. So,
Nope, I can still see you.
Very good. So that being said, I don't know what else I could add to that. I'm sorry, I don't.
Nope, that's perfect. That is absolutely perfect. Laurel.
Hit me with it.
Okay, getting ready to wrap it up. So I know you mentioned at the beginning an amazing example of a judge, but does anyone else come to mind as an amazing example of a judge?
Oh, I had a unique opportunity when I worked in insurance defense, and then as I worked as a prosecutor, where I never was really stuck in one courthouse. As an insurance defense attorney and subrogation attorney, I practiced all over the state. As a special prosecutor, I got to practice Tarrant County and in several counties west of it. So I got to see the differences in the way judges carry themselves and the way they act on the bench and the way that they expect people to do stuff. I've been in front of some wonderful judges. I wish I could give you some more names. But there is this goofy thing we do once a year, this judicial education seminar. And now that I'm in this peculiar club, I get to go to that. And I'll run into these judges. And that's when you sort of get to say, hey, Judge Kincaid, or, it good to see you again. Do you remember that case we had? And you get to learn a lot from him. There's a judge in Fort Worth named Jesse Navarez. I always enjoy talking to him. There's never a conversation I've had with that guy where I don't learn something. And he just, irritates me to no end because, he looks like he's 25 years younger than he is. And I have no idea how he does that. But he's also got one of those temperaments where you just feel like I want to be that guy, I want to be unflappable. So we're at least I hope good judges are aspiring to be a little more zen than they are, vim and vitriol. I've watched judges scold people from the bench, and I've just never thought that was going to be me. And on occasion, you actually have to tell someone, you're out of line. You're going to have to, there's a jail cell right around the corner. You don't want to be in there. So you need to sit down, you need to behave yourself. And people will generally respond favorably. So, and if not, I have wonderful deputies, and they'll walk them out and take them down the elevator, bid them adieu, and off they go. They're out of the courthouse. So.
So what has been your least favorite moment on the bench?
There are cases that involve tragedies or deaths. That stuff's very difficult. And when it involves the death of a child, it can be even worse than you anticipate. So those are part of the landscape. The only prayer I have is that when judges have to hear those cases or do that stuff, that they're the right person at the right time to hear it and resolve it. So that's the low point. Cases that involve tragedies or deaths.
Well, on the other end of that spectrum, what has been your most favorite moment on the bench?
Oh, those are the unapologetically sweet moments, your adoptions, I've performed a couple of weddings, that stuff's a giant winner. Everybody that buys a ticket to one of those things, they come out feeling happy. It's the romantic, movie ending they want to see. But some of the best cases, some of the best moments are the cases where I learn a lot from. So it might not have to do with the outcome of the case. It might just simply have to be a case where, I was, and I don't have a problem saying this. We're going to take a 5-minute recess. I'm going to go back to my chambers and read some law. I think the lawyers appreciate that a lot more than I'm going to throw a dart at a dartboard and pick an answer. They don't want that. They've worked too hard to get there, right? I should show them the respect of saying, you're going to quote Texas Family Code 9.101. I better go take a look at what that says. Okay, great, and I'll go do it. So those are always worthwhile. The ones where you learn the very, very most. So, and it always makes the next case similar to that much easier. So.
All right. Very, very last.
All right.
Would you like to tell the audience anything? Absolutely anything at all. It doesn't have to do with your time on the bench, but.
Yeah, absolutely. I will tell you this. It's becoming a judge was not a goal. It was not an objective. I didn't grow up thinking I'm going to be a lawyer and I'm going to be a judge. Like I said, I didn't plan on being a judge or a lawyer until I was 35, and I went to law school. And oh gosh, in 2018, or 2017, I was 51 when the opportunity came to seek a bench. I would say this: there is never a moment that is too late to make a positive impact on maybe your career aspirations or your next step. I mean, Aaron, you might be thrilled with a law practice you set up, and then someone's going to come along and mess that up and say, I want you to go to The Hague and be a war crimes tribunal prosecutor for the next 3-year tour of duty. And you might think, why would I ever do that? And then you might think, why would I not? You know, and that's the cool part, you know, becoming a special prosecutor. I mean, when you come out of law school, you can become a prosecutor. But after you've been a lawyer for 10 years, almost nobody goes and becomes a prosecutor then. And so when I did, and I got to move into an area I knew something about, which was the white collar world, to me, that was, you never know these opportunities are coming. And so, you know, keep your mind open, and the never close it off. If you feel like you've done poorly at a trial, ask to go talk to the judge afterwards. Hey, listen, you know, can I get some critique? How did I do? You know, well, you were an absolute catastrophe putting on your own witnesses, but you had a dynamite cross. Maybe you should work on putting your own witnesses on a little bit better. Oh, okay, cool. And they'll take notes and they'll get on it. I did that several times. I mean, you're not trying to ex parte an issue. You're trying to get a professional tip. How did I do? Did I do okay? Yeah, you're great when you're following your swim lane, but you got to understand the other guy's going to put on a case that's not in your swim lane. And so you got to be flexible enough to get that. So it's okay. It's okay to ask, just like it's okay to ask the jury for comment after the case. You know, you might hear stuff that you think, oh, they're nuts. They don't know what they're talking about. But you might hear something and you're like, you know, I was worried about that. I thought that was an issue. Let me make a note. I'll work on that next time. So, and there is a creative bit of editing too. At times, you're going to come to court with a case where you've got 12 boxes, and you can just hammer this person into the sand on the other side of the case. But really what you need to win the case is contained in one box. So putting that on is helpful. When I was a prosecutor, you get to file this thing called a 404B motion. These are all the bad acts that I want to tell the jury about in punishment, because I want them to shoot off to the big end of that punishment spectrum, right? There may be some offenses I just don't want to put on there because they're so out of character with what I'm doing. I don't want to lose the jury. I don't want to lose their attention. In civil trials, looking at the pattern jury charge before you draft even your opening or your close, the pattern jury charge is the questionnaire they're going to fill out in the end. Everything you do in that courtroom should be oriented towards getting them to answer those questions in the way that you believe the outcome should be. So spend a little time in the pattern jury charge before you go in there. Some of these things are just, they sound like homework, but they're not, because all of a sudden they make your case crystallize for you. And that's a nice moment. When you roll into court, you put your boxes up, you sit down at trial table, you pull out your first folder, you're ready to go. Or you pull out your binder if you use binders. I use a folder system, but it was always right next to me. When I was done with witness A, I went to witness B. I'm ready to go. And in that folder was my outline of the basic questions I was going to start with and the exhibits this person was going to admit, you know, and I was organized and ready to roll. So that the prep time can really matter. So keeping that in mind, I love litigation. Not everybody does. Some people want to do something else. There's nothing wrong with that. We need people to process title policies. We need people to do closings on real estate. We need people to draft wills and contracts, and that's important legal work. But what got me to pay attention in law school was the opportunity to be in a courtroom one day and point fingers and make gestures and put up exhibits. And when I finally really got to do it, I thought, man, I've made the best decision of my life. I mean, I had no idea, it's not about money. It's not because you think you'll make a fortune. If we wanted to make a fortune, we could go into a different profession where fortunes are made, right? The law is a business where fortunes are made and lost. So, and in the end, your clients will either love you or hate you, depending on the outcome of the case. But as long as you did your level best, you've got nothing to hang your head about. You go on and take the next client and do the very best you can for them. Okay.
Absolutely excellent, Judge. Everyone, this is Judge William Wallace from the 378th down in Ellis County. Thank you very much, Judge, for being here and sharing all of your insights with us today. This is going to be extremely valuable. We're going to put this out everywhere, Texas lawyers, YouTube, for anyone who comes up in front of your court to hopefully watch beforehand. My name is Aaron Cartwright. Again, I do business securities and construction litigation in Dallas, Texas, but all over Texas. And this is my co-counsel, Laurel Curtis.
My name is Laurel Curtis. I work with Aaron Cartwright. I also do construction litigation. I also dabble in general civil litigation and your very fun, complex business cases. So thank you, Judge Wallace. It was a pleasure. I learned a lot. I hope everybody else watching also learned a lot. And make sure you guys join us next time.
Enjoyed it very much. I hope you guys have a wonderful evening, and we'll see each other again soon, I'm sure, and maybe I'll see you in court. All right.
Thank you, Your Honor.
Thank you.